Welcome to Dad Talk Today. The podcast for dads facing some of the toughest moments of their lives. We are here to walk with men through divorce, keep them connected to their kids, help them understand their rights, and work for change in family law courts. Moms, you are always welcome too. We are all about advocating for shared parenting and doing what is best for our kids. Here is your host, Eric Carroll.
Hey everybody, welcome to Dad Talk Today. It's a Monday night. We are back with Kevin Hickey. Kevin, what's going on, man?
Hey man, how's it going? Happy Monday.
Yeah, it's definitely a case of the Mondays. Guys, we're doing our live Q&A. If you got questions for Kevin, put them down in the comments and I'll bring them to you. Nothing about this is to be taken as professional legal advice. He is not your attorney. But he's given his professional opinion and we'll leave it at that. But anyway, guys, if you got some of those, put them down there. I guess we could start off, though, Kevin, while we're waiting on getting some questions. We was just talking about it. Like when you hear from a new client, what is the best way that they could speak to you? Because I know a lot of times, like when I hear from people, I just get, the pages and pages of, hey, here is my story right here. And they want to get out every little detail. And sometimes that's a little hard. And I think Kevin just froze up on the screen. So he'll probably be back here in just a second, guys. But yeah, man, while we're waiting on Kevin to get back, if you will bring me some questions, I will get those up. It's a great time. You got to put it down in the comments, though, guys. So we got a big week lined up. We head off to Illinois tomorrow. And a lot of us will be going up there. I think we're going to hit the Capitol and go and talk to some people about shared parenting and see what we can get going on there. And we will have some exciting stuff. Guys, I booked a guest today. It won't happen until next month, but I can't wait to share it with you. I'm very excited about this. It's somebody that I really looked up to when I was a child, especially musically, and I think you're going to like it. So lots of good stuff coming up. There he is.
Sorry about that.
Yeah. So what I was asking you, Kevin, before you froze up we was kind of talking about a little bit before we got on. What is the best way when somebody's trying to find an attorney, how they can bring their case to you? Because I know there's all these little details and nobody ever feels like they can get the whole thing out. But what is the quickest way and most efficient way that they could come and tell you what they are needing?
Well, I always have some general initial questions that I want to know. And it helps me if the client will just, for at least a minute or two, let me ask some questions so I can kind of get the lay of the land. Sometimes they'll just start right in their story and I'll let them go on for a while and tell me, because I need some of that background. But usually when I get a chance, I say, can I ask you a few questions? And they always say that's fine. But I want to know when the last time you were in court was. Obviously, I want to know how many children are involved. If it was a divorce, when the divorce happened. Have you been back to court since the divorce? What happened in that hearing? What was the custody arrangement after the divorce? What is it now? And then I want to know what their questions are and what they're wanting to do at this point. So those, I try to get that gives me a timeline that we're dealing with. And it's really important when you were in court last, because when we're dealing with a change of custody, we're almost always dealing with language that talks about a substantial change in circumstances. And every state is different, but that's kind of a general rule in each state. Excuse me. We've got to look for that change in circumstances. And if you were just in court a few months ago, it's very hard to show that, because the judge is going to wonder why you're already back so fast. We were just here. What has really changed since we were here?
Right. All right. We got some questions coming up, guys. Like I said, put them down in the comments and we will bring them to Kevin. This one comes from Stephen Menzel. He said, can you write a judge to tell them how their decision has affected the family?
Well, the answer is yes. Just because the answer is yes doesn't mean it's something you should do. I never like it when clients contact the judge directly. In fact, I've had more than one situation in over 20 years where a client has contacted the judge. And I even when they've talked about, well, I'm going to send something to the judge, I advise them, please don't do that. And if they won't really listen to that advice, I mean, I've gotten out of a case before for that exact reason. So I never advise contacting a judge directly. It just never seems to make any kind of a positive impact on your case.
Yep. There's another part of that. I had a guy one time, he called a Guardian Ad Litem and had recorded it, and he sent it to me afterwards, and he was like, Eric, what do you think about this? And I was like, well, let me ask you a question. I was like, what does your attorney think about that? He's like, well, I didn't tell him. I was like, well, I think that's where you might want to start.
Yeah, you really need to. And I think people many times they're not very trusting of attorneys. And I think there's kind of a bad rap out there. I think there are a lot of attorneys out there that have unfortunately given the profession a bad name. And I think a lot of people in the general public do not have a lot of trust with attorneys, even their own lawyer. And so they withhold information or don't share the whole story. And I've told clients before, look, that doesn't hurt me. I'm your attorney. I'm trying to help you. The only person that's going to hurt is you. If I know all the information, then maybe we can prepare for it and decide how we're going to handle it if it's negative information, but a lot of people just won't tell you everything. The last place I want to find something out like that is in court, because by then I haven't had a chance to think about it. I haven't had a chance to maybe bring in a witness that could help us or a piece of evidence that could help us. If I just find out about it at the hearing, it's just going to hurt your case.
Yep. We got one from Brianna Harper. She said, when the other parent's family members make life threats towards the other parent and their family, what's the best way to handle since there is a child involved?
Go to the prosecutor. I mean, if someone is threatening your life, that's a crime in every state. And that is grounds for an order of protection usually, or restraining order. They're called different things in different states. You need to go to the police and probably the prosecutor and look at getting some kind of an order of protection. That is not to be taken lightly at all.
Sorry. David Blake said, if children have a second phone and the father's number is blocked from those phones, is okay. If a children have a second phone and the father's number is blocked from those phones, I'm guessing he's saying, is that okay? Now they have another phone, but when they get to their mother's, it gets taken from them and turned off. What's your thoughts?
David, that's a very good question. And it is something, especially in this new I say new technology, I sound like my father or grandfather. We've had cell phones around for years now, but that has been a problem that has cropped up ever since we've had cell phones and iPads and iPods and all kinds of tablets where you can talk back and forth. One parent will either discipline a child and take their phone away that might be paid for by the other parent, or they'll ground them from it, or they'll just flat out say, you're not using your mom's phone or your dad's phone when you come in this house. Usually you need to write something into the orders, the custody orders that you've got. If we've had a custody case that's been going on or a divorce case that's going on, and it's been a problem throughout the proceeding of that case, usually the client and I will try to address that in an order and say, look, from now on, when you take your phone to the other house, you're allowed to use it. If you're going to be grounded from that phone, then you need to notify the other parent and make sure there's a way to communicate. Judges and especially ad litems want to make sure that the children have access to either parent, no matter whose house they're at all times. So if you're going to take that phone away, then you need to give another alternative for them to be able to communicate with the other parent. So the best way to handle that is put some kind of provisions in the order that talk about the phones either going back and forth, or they won't be taken away, or something along those lines.
All right. We got a question in here, Kevin, from somebody that wanted to get this in anonymously, and I understand why they're doing that. He said, hi, Eric, could you ask anonymously this question to Kevin? What are your chances of getting a restraining order overturned that I was forced to agree to because I did not have the money to fight it and multiple other charges brought against me. In other words, I was forced into a type of plea bargain, even though the charges were in each situation false, false, false. What are the dangers of having a 2-year restraining order, civil charge, and criminal hanging over your head, even though you did nothing wrong and now can no longer protect your kids from the alienator or contact or communicate with your kids?
Well, there's a lot of information there, and I know it's anonymous, but I do want to make a disclaimer that that's either someone that's not on the other side of a case that I'm in or something like that. This would just be a general question. Yep. You can appeal an order of protection just like you can appeal anything else. In Arkansas, you have up to 30 days to appeal an order. And if that time has passed, I don't know that there's much you can do. We have gone back in some cases after the appeal deadline and asked that the order of protection be terminated early. Some of them are valid up to a year or 2 years. But we've gone back and asked that they be terminated early or modified in some way. So that may be something that you need to do or look into.
Yeah. David Rittenhouse said, I am a commercial airline pilot and I have an irregular schedule. I've had shared custody. My daughter is now 12. My ex filed for modification. I'm away 17 days a month. I want the rest when I am home. They are now saying I need a more regular schedule or I get less. Why?
Because of your schedule. Should you be penalized because of the type of job you have? You're an airline pilot. That's a great job, great paying job. And fortunate that you have a job like that in the economy that we've had and with COVID and everything else. The downside to that job is the irregular schedule. And it's hard to always think of it this way, but remember what the poll star is, what the judge is thinking about in every case dealing with custody. What is in the best interest of the child or the children, not what is in the best interest of one parent or the other, or whether one parent or the other should be punished or not. What's in the best interest of this child? My guess is with those remaining 13 to 14 days each month, they're worried that the child will be at your house 2 or 3 days, then flip over to the other house for several days in a row and then come back for a day. I don't know. That may be part of the problem, is that the child's having to move around a lot. The best thing you can do is try to show that your schedule when you are home is not going to be that disruptive to the child's schedule, and that you can make it work and make it stable. And it helps if your daughter's 12. She can talk with an ad litem. She could actually testify, at least in Arkansas, she could easily testify if that's something you wanted to do. And she could talk about how this schedule is okay with her, and she doesn't want to be at your house those other days. That's about the only way to combat that. I'll tell you another situation this comes up in is people that have really good jobs on the trains. They have real irregular schedules. They can be called out at different times, and when they're called out, they're gone. I mean, they're not in town anymore, and it's real hard to come up with schedules for workers like that.
Yep. Lily Black said, if your state's recording laws allow it, should you record interactions with Guardian Ad Litem? Moore versus Child Advocates, Cynthia Dean and Dale Anderson, Indiana.
I don't know. I guess that's a case there at the bottom.
That's what I was thinking.
You know, I never liked that. I mean, you can think about yourself. If you'd like yourself to be recorded, and people say, oh, what are you going to lie? No, it doesn't have anything to do with that. It's just that knowing that there's recording going on, it makes people, it really can kill trust in any kind of relationship, either an attorney-client relationship or even relationships with friends, witnesses, whatever. Once they find that out, it's like it's something that they remember about you, even though that case is going to be over soon from then on. And you know, the question is, should you record interactions with a guardian ad litem? I have an issue with it. I mean, I think if there are a lot of problems with the ad litem, and and things are getting twisted, maybe you could. I would feel a lot better if you went to the ad litem and said, during this meeting, I want to record what we talk about and be upfront with it. But I don't know. I just never get a real good feeling about it. And Eric, I don't know, you know, you've been doing this a while too. I don't know what your thoughts are on that too, just from a non-attorney position.
I've seen both sides of it. I've seen the sides, you know, where you get the ones that no matter what you do, no matter what evidence is there, it seems like there was maybe a preconceived notion before that case is started, and there's nothing you can do to make them feel otherwise. And where cases that might need to happen. But I would say, you know, it's case to case basis, kind of like you was talking about. Let them know what's going on. Make sure, because I know different states have different laws around recording. So guys, use your best judgment. That's somebody that's still involved in your case, and you could also piss them off.
As we talked about earlier, certainly do not do it without talking with your own lawyer first.
Yep. And that's happened many times. And I'm like, man, if you got an attorney and you're not taking his advice, what are you paying him for?
That's right.
If you don't trust him, you need to find you a new attorney.
That's right.
So, all right. This is an interesting one, Kevin, because we see this a lot. Rick and Lisa Young said, your military service used in court to portray you as a trained killer. And I had a question mark, happens regularly to veterans. I think one of the most heartbreaking testimonies I saw when we was in Texas on the 50-50 bill was a father that got up. He's not being allowed to see his child. He's had the false allegations going, and PTSD and everything was used against him. And he said, you know, I was over in Iraq. I led our troops to war. And he was like, I was allowed to have that responsibility out there on the field to fight for my country. And I come home and I can't even have my rights and responsibility to take care of my own children. This guy was in shambles. And it's an all too common scenario where their service is used against them, and not just the military members. You know, I was up in Michigan not long ago, and I talked to a lot of the UFC fighters. What they do for a living is used against them, even though they are trained and they don't want to fight. You know, it was just something that they do for a living. But it seems like people's careers and what they do can be used against them, especially when it comes to our military.
Well, I have a soft spot for people in the military and veterans, and I've always said they should have the best health care. They should have the best mental health care because of everything they did for our country. And you're right. Many times when I'm representing someone that was in the military, especially if they served overseas or in some other area of combat or in an active situation, PTSD comes up. Many times they haven't ever been diagnosed with it. The spouse will just say that they have PTSD. So that's one thing we try to do in the case is show that there's never been a diagnosis for that. Or if they have been diagnosed with it, they're getting it treated properly through their doctors. As far as portraying you as a trained killer, the thing that you have to do, and this would go with UFC people or whatever, anybody that engages in activities that are considered violent, you've got to show that that's just one part of you. That's not your whole life, and that's not the way you treat everyone in your life. You've got to show that you're still a compassionate parent. You can still take proper care of your children. There have never been any instances of problems in that area or that you've harmed the children. Those are the things you've got to show. And I think judges are very good about listening to all that evidence and looking at you as a person. In Arkansas, and I think the 2 or 3 statutes we have on this are very similar to laws in other states. It talks about, and I'm paraphrasing, but it talks about that the court can't use your military service against you in a custody determination. Now, if you're getting transferred a lot, that the court can consider that, but your military service and the fact that you are in the military is not supposed to be a factor. So that's one thing that we've used before in cases to help.
Yeah. You know, I think you think it would be fair to say, like, people that are going through family court that are ex-veterans, PTSD is so quick to be used, kind of like any child that's experiencing behavior problems. We're so quick to diagnose them with ADD.
Yeah, PTSD, narcissism, egomaniac. I mean, all these words are used for a lot of these military guys that did have some pretty intense training so that they could do what they needed to do when they were put in combat situations. But if that person is having that taken care of, they're under proper treatment, or they're able to not have that part of their life be part of being a parent, it shouldn't be held against them.
That's right. We'll get on to our next one. Summer O'Brien wrote, do allegations of abuse automatically meet the change in circumstance burden to get a hearing in family court?
That's a very good question. And I guess my answer would be no. It depends on the type of abuse. It's similar to, we talk about parental alienation is on a scale, a 0 to 10 scale, 0 being minor and 10 being extreme. And I think abuse can be the same thing. You can have a 0 to 10 scale on that. So just allegations of abuse are not going to be enough to meet change in circumstances. You're going to have evidence to show that there is abuse going on that is affecting these children, and something needs to be done about it, and a change needs to be made.
Yeah. All right. David Blake has said, what's your opinion on a step parent not being able to see or talk to their own biological child? Should that person be allowed to be around someone else's children? I guess that's going to be more of you're going to need the details of that specific case, right?
Yeah. And it says step parent not being able to talk to their own biological.
So you got a step parent that has a child, I guess, from a previous relationship, and something's been going on, Kevin, like they've been accused of something or something different. They've gotten a new relationship. They're with this. They're either their new spouse or their new boyfriend or girlfriend's child, but they're not allowed around their own biological child.
Okay. Every case is going to be different on that. I'd need to know the surrounding facts as to why they can't see their own child or can't talk to them. But if there's a good reason for that, or the court said they can't be around that child, then that could be an issue with being around their new partner's children.
Yeah, that's a sticky one, because allegations are real and abuse is real at the same time too.
That's right.
Absolutely. I'm sorry to hear about that, David, man. I wish we could give you a more definitive answer, but I don't think there is one without looking at it clearly. Fletcher Thompson said, my ex wants me to make my life insurance in her name. I know it's more common for an order than most realize. Our relationship is lacking, to say the least, and I fear she would actually consider harming me to collect. How have you all found dealing with life insurance? Naming someone as beneficiary and trust to child.
It comes up, and many times if we have alimony or something like that that's going to go on for several years, that's being paid to a spouse, that other spouse will request that they be a beneficiary of a life insurance policy, just in case the paying spouse dies, something like that. You've got a fear there of that they may try to harm you to collect on it. I wouldn't agree to it then. I mean, there needs to be some kind of support for that fear. And I know you may not have something like that, but all I can tell you is life insurance it's not uncommon to be used in divorce settlements to help with a financial settlement, either for alimony or some property division or some other reason. We've used life insurance before.
It sucks because somebody can make an allegation, PTSD can be used against them, but in cases like this, and is so easily, used inside of the court. But in cases like this, guys, you got to have evidence. You got to show them.
And down there at the bottom, it says naming someone else's beneficiary in trust to a child. Absolutely, you can do that. You can name the child as a beneficiary. Obviously, if you're saying child, they're probably still under 18, so they're a minor. You usually have to give the life insurance company some kind of information about a trust that would be immediately created for the child to receive the money.
Yep. Lily chimed back in. She said, if you are pro se, shouldn't you be allowed to have a copy of the case file just as an attorney would? Here they charge pro se litigants $1 per page.
Yes, you should. I'm assuming they would charge. I guess she means the court clerk. If she went to get a copy of the file, they're charging her to copy it. It should be the same fee for an attorney or someone from an attorney's office that went over there to copy it. But yes, any part of the file that's over there, you're just as much entitled to it as an attorney is.
Yeah. We got one from Sierra McAllister. She said, father lost parenting time due to him not being able to remain sober for his scheduled parenting times. Plus, a recent restraining order is in place. We went to mediation, modified the HRO, and agreed for video calls to take place twice a week. He has only called them a quarter of the time since our agreement. What should I do if their father is not exercising these calls now?
I'm not sure what state you're in. Here in Arkansas, I think there was a case on this issue. It's been a while since I've looked at it, but it talked about that just because visitation's ordered doesn't mean that the person has to exercise it. So just because he's been given that in an order and you went to mediation and that's what he agreed to, he doesn't have to exercise it. I mean, it's his loss, but he doesn't have to. I have advised clients before, give it some time. I don't know how long it's been since you were in mediation and put this agreement in place. But after a while, if that continues, you can go back and have it modified to have his time lowered. You shouldn't have to continually make the children available for calls or other visitation. You have a life and a schedule too. And if he's going to continually not show up, you may want to go back and have it modified.
All right. Cody Gerke has said, I have a custody court date next week. Is there anything I should know to better prepare myself?
Just stay in contact with your attorney. If that's your final hearing, you should be in the final stages of, if you haven't already sent subpoenas out for people you need there, you should be starting to do that. Just don't get into conversations with the other parent. Emotions tend to get run higher and higher as you get closer and closer to the court date. Everybody's nervous, worried about it and everything else. And sometimes you can say things that you later regret. So the best thing you can do is just keep being a good parent, stay in contact with your attorney, and just be ready to go.
Let's take a second and talking about those emotions, Kevin. I think a lot of times people think I can keep my composure. I already know what's going to go down. Then you're sitting in that seat. You're hearing these allegations. You're hearing the money they're wanting to take from you. They're wanting to give the house, or they're giving full custody over here. That could be easy for anybody to lose it in those situations.
One of the toughest things, and people will many times ask me, does it matter who files for divorce first? In Arkansas, not really. I mean, as far as giving you an advantage in the case one way or the other, it really doesn't. But there are times that it does. And one of them where I try to file first is in a custody case, because the reason is whoever filed first and initiated the court action, they get to present their case first once you get to the hearing. So you get to put all your witnesses out there and all of that. When you're on the flip side of it, it's exactly what you were just talking about. And I have to put my hand over there in front of my client and kind of whisper to him, this is going to be hard for a while. You're going to have to hear all the negative stuff before we get a chance to present our case. And it's true. You have to sit there and listen to all that. But it's just part of what you got to do. And yeah, it can make you upset and whatever, but just know that you're going to get a chance to present your evidence, and you just have to get through until that time comes.
We got one in here from Mr. Tom Mineo. He said, have you ever filed a contempt of court and it backfired on your client? I am pro se and it's clear X ignored order even after repeating the contempt to X. How can my filing for contempt backfire on me?
Well, I guess there's a bunch of ways that could happen. If the person really violated the order and you've got good proof of it, I don't know how it can really backfire on you. The one thing that people have an issue with, and I understand, is they feel like sometimes judges don't do enough to the person that's in contempt. They feel like, look, this was in a court order and you were supposed to do it, or my ex was supposed to do it. I go back to court and the judge just says, now don't do that again. They don't really put any punishment out there. As far as backfiring, I don't know if that's what you're talking about, but sometimes people will go in and think that the judge is really going to hammer this other person because of not following the order, and it doesn't always work that way. So you'll want to talk to your attorney about, well, you're pro se, but usually you'd want to talk to your attorney about different judges, how they react to contempt, how many times you have to get back in front of them before they'll really do something and punish the other side. Those are the kinds of things you have to think about when you file for contempt.
Yeah. Mr. Matthew Edwards said, will a judge grant sanctions to enforce a custody agreement?
Yes, I think the answer is yes. You can sanction the other party. Many times we're sanctioning attorneys, but you can sanction the other party. And they can be held in contempt as well if they're not following it. Sanctions are usually some kind of a fine or attorney's fees or some kind of monetary sanction, but there could be other sanctions as well. So yes, I think you could. I think you could do that.
Amanda Jones said, what happens when you file a contempt order? In Georgia, cops will not get involved when parent won't allow visitation, etc. So advice on filing a contempt, is it a waste of time? Many attorneys I have spoken with have said the judge is likely only to give mom a slap on the wrist.
This is exactly what we were just talking about. What happens is, and it's a little bit different in every state, but you're basically notifying the court, you're notifying the judge, look, judge, you put this order in place and I've been following it, but the other side is not. And we need you to do something about that to get their behavior in line with what you ordered. That's what happens when you file it. The other person is served with it. They answer. They almost always answer and say that that's not correct, or there's a mistake in facts or something like that. They deny what happened, and then you have a hearing and the judge decides what to do. Is it a waste of time? And many times it's hard to tell that on the front end. If you have an attorney that you're working with, that attorney, if they've done a lot of these kinds of cases and have been in front of these judges a lot, will be able to give you a little bit of an idea of what the judge may do. I have many people call. I think most attorneys that do family law get a lot of calls from people, consults with people, bringing up issues just like this, saying the ex is not following the order. What do I do? And it's a case-by-case basis whether I tell them it's severe enough that they need to go to court or not. And it just depends on what it is, how often the violations are occurring, whether I tell a client, yeah, I think it's worth trying, or we can file for contempt. You can hire me to do that. We can go to court, but I just don't know that the judge is going to do very much to the person. You just never know.
All right. Now, our next question, you know what, Paul, you're going to have to tell me if I pronounce this one right. I'm going to guess Paul Ilf. I think the N is silent. But he said, my ex accused me of being verbally abusive when in reality, I'm just upset about never being able to see my kids. And I'm upset she's trying to alienate me. I think it's normal for a loving dad to be upset his babies have been taken away. Can she really use my emotions against me in court?
I think, well, to answer the question at the end, yes, but you can also use her behavior in court. I mean, you need to be able to highlight what she's been doing. You really need to, I know it's upsetting, but you've got to watch the language that you use. You've got to watch what you say on voicemails or through email and text and whatever else. You got to be careful. Don't post things on social media about your ex, and even if it's memes or whatever, you can't do that. You can't go there. You have to assume that everything you send in a text or an email, voicemail, social media, you have to assume that all of that's going to be on a screen when you get to court. And you don't want that on a big screen in front of the judge where you said a lot of things you shouldn't have said. The best thing you can do, especially if you have a significant other in your life or a good friend, before you respond, let them help you with the response. Let them help you kind of think through what you should respond with, instead of your initial reaction of being anger and wanting to immediately send something back. You got to think it through or sleep on it or something like that. But if she's alienating you and behaving in that kind of way, you need to get all the evidence you can about that and present it in court.
Yeah. All right. So this isn't so much a question, but I'm going to read this comment, Kevin, because it's in Arkansas, and I know you'd be familiar with it. Amber Leanne Flores said, in Arkansas, I never got to listen to the other case presented. I wasn't allowed into the courtroom. Now, is there times where they're not going to be allowed into the courtroom, and what would the reasoning behind that be?
If you are a party, there should not have been any reason that you weren't allowed in the courtroom, especially when we're talking about the other case being presented. You should have been in there. If you were not a party, then you can be excluded, especially if you're a witness. There are times in Arkansas where we have children testifying if both parents will agree to wait out in the hallway while the child testifies, which is always advisable so that the judge can see that the parents are not trying to put pressure on the child by sitting there listening to their testimony. Sometimes, the parents will go outside for that and won't be in there for that part of the case, but not while the whole other side of the case is being presented. You should have been allowed to be in there. And now it is, Eric, kind of the question you answered. It is possible that a party can be excluded. I think I've had it happen one time, and it was not in a family law case. One time in 21 years, it was a criminal case, and I was representing a defendant, got appointed, and he just was so disruptive that there is case law in a case like that where if you can't have just a general court proceeding because this person is so disruptive, they can be excluded.
Gotcha. Borna Nemesis on YouTube said, why is it that my toxic wife, whose false allegations kept me from my 3 and 5-year-old kids for 3 months, has gotten to do whatever she wants in this divorce through lying, stonewalling, and darvoing? You're going to have to explain darvoing to me, by the way, but go ahead.
You'd have to tell me that. I don't know what that is either.
Okay.
But, if, when you've got somebody with false allegations, it's like a train leaving the station, and you've got to try to either get that train off of that track or stopped or whatever before it gets down the track, because it will gain steam fast, and you've got to head it off sooner rather than later. And it sounds like what you've got, this has been going on a while, and she has just got such a snowball going down a mountain of false allegations and everything else that she's got all the momentum right now. And all you can do is try to get all the evidence you can together, get with your attorney, and try to turn the tables somehow.
Yep. So darvoing is an acronym for deny, attack, and reverse victim to the offender. I learned something new tonight.
It's a little like, what's it called? Gaslighting.
Yep.
That sounds a little bit like what that is.
You know what? And keep the documents on that, brother, because if somebody's really doing that, those behaviors, sometimes, people can tell what they're doing.
Mm-hmm.
You know what I mean? If somebody's really educated in it, and sometimes they're very good at what they do, but I'd make sure I'm documenting everything, which you should be doing anyway.
Yeah, you have to, because that's the only way you can combat it. You are not, and this is real important, you're not going to win a he said, she said in a situation like that. Not now that this much time's gone on, judges want to see beyond that, because judges know that dad is going to say everything he can to help himself, and mom's going to say everything she can to help herself. You need documentation, texts, friends that have witnessed how she acts. You need to get that's how you build your case. Because that's what's gonna get you over the hump in that case.
And most of the time, if she's doing it to you, she's done it to somebody else.
Other people have seen the behavior. That's correct. That's correct. Yeah. It's that's for another time.
Brenda Padot said, how can you request a new judge even before ever being in front of them?
It's hard to get a judge recused. This question actually came up in a client consultation I had today with a client, talking about the fact that a judge that just got assigned to one part of the case actually was an attorney for the other party in the case back in the day. That's usually a conflict of interest, and the judge will step aside. You usually have to have some kind of a reason like that, Brenda, if you're going to ask for a judge to be recused right from the very beginning. There has to be either some kind of bias, they have to have some kind of relationship, either family or friend or professional, with one of the people in the case. That's the kind of stuff you need to show, or they have some kind of other bias that's unrelated to that, but something that does not make them a good fit for that case.
How often do you see that successful?
Not very often. And I'll tell you this too, Brenda, I always, if I find out that the judge that is on a particular case I have has a conflict and I think they need to get out, I don't file. My first step is not to file a motion with the court and put all that out there. I usually either call them with the other attorney on the phone, or I send a letter that says, Judge, my clients advised me of X, Y, and Z, and you may have a conflict. You may want to step aside. 9 times out of 10, they just go ahead and recuse themselves. But I give them an opportunity to look at it and see if they think there's a conflict first before we file something with the court. And then they usually, what happens after that, just so people know, if the judge says, yes, I need to step aside, they usually put what's called an order to transfer in, and that case just gets transferred to another division. And then a new judge is assigned, and you go on as normal.
There you go. PJ Farias said, my big question is that is all good, but it's tiring that X accuses me of everything under the sun. She has gotten my kids to tell me daily they don't want to talk to me. They are 11 and 13 and 16. The fees for court are astronomical in Tennessee. I'm at my wits' end with it all.
If she's accusing you of all this stuff and it's all false, get a list together. If I were your attorney, I'd love nothing more than to present a laundry list exhibit, put it up there on an easel or something for the judge to see, that shows all the stuff she has said, alleged, tried to get the kids to believe, and all of it was proven false. That sends a huge message to that judge that, look, I'm not the problem. She's the problem. She's the one that's creating all of these accusations and allegations. Your children are a little older, 11, 13, and 16. I hate that they're, not wanting to talk, but that's how you combat it. And again, it comes to documentation, but you got to show that judge that look at all these things over this amount of time that she's alleged, and all of it's false. She's the problem.
Yeah. And I'd just like to talk to you that last one at the end bothered me a little bit. He said, I'm at my wits' end with it all. Let's family court aside. When somebody starts making allegations, they start alienating you. That's what they're wanting. They want you to feel like you're at your wits' end, mm-hmm. and that you're going to give up. They want it to stress. And that right there, you're giving them what they want. Keep your cool. It's easier said than done, but keep your cool, man, because you're in a battle, and realize it for what it is. And, it's a trick.
It is. And that's part of the design. And what do we talk about when we talk about alienating parents? When they are the alienators, they just want to win at all costs. That's one of the biggest things that they want. They don't care about the kids many times. They just want to punish you, and they want to win. And
that's it.
Then that's what happens.
Yep.
I mean, when I say that's what happens, I mean, this is what happens to the other parent many times. They do feel like they're at the wit's end, and it can be demoralizing, but you got to hang in there. Talk to people that you know and love that are close to you, either friends or family. Make sure you have a good support network around you, and lean on them.
You see all these questions coming in with people that knows what it's like to be in your shoes, man. You're not alone. But don't give them what they want is what I'm going to tell you. Keep fighting. Keep your head up, and show your kids you didn't give up.
That's right.
Yeah.
That's right.
Stephen Creasy has said, and this is important, guys. I know we've went over it before, and this is a very, very common misconception. But he said, my ex is taking child support out on me. Do I have a right to see my kid? You should, but does he, Kevin?
Well, yeah, they're two separate things. Most states look at child support and visitation with your child as two separate things, but and I don't know if this is a paternity situation or not, but yes, I mean, you do have the right to see your child unless something's happened that a judge has ordered differently. If that's your child, you have every right to have visitation, to ask for custody, to have a schedule put in place. You can do all of that. Many times a question like this will come up. Someone will come in, usually a guy will come in and say there's been a paternity action filed against me by child support enforcement or something like that. And that usually means the mom has asked for child support or she has applied for some kind of state assistance. And so child support enforcement gets involved and tries to find the biological father and make them start paying child support. They won't do anything with visitation. And so these guys will come to me and say, well, child support enforcement, started child support on me, but they didn't set a visitation schedule. Well, they won't, and that's not their responsibility, but a private attorney can come in and help you with that and get a schedule put in place.
Yeah. And, it makes it even more, it makes more obstacles if you're not married. Because I know, like, when I started paying child support, I had the same question as you, Stephen. But before I could go for that, I was told I had to legitimize the child because I wasn't married. Then I had to go and, sue for child support or my custody rights. So
that's exactly right.
I think you should, but it's not the case, brother.
Yeah.
Matthew Edwards said, if extreme alienation is present, will a judge just take a child's word on the stand? Judges and gals do understand alienation, ? I guess it's according to what judge and what Guardian Ad Litem. It
is. And judges that have been doing this a long time and doing a lot of family court issues, even if they don't, and we talk about this a lot, Eric, even if they don't use the word alienation, they understand the behaviors. And if one parent is trying to keep the other parent from being involved. So if extreme alienation is present, will a judge just take a child's word on the stand? Absolutely. A judge, one of the biggest things that a judge does when they're sitting there and listening to witnesses, they're listening to what's being said, but one of the biggest things they're doing is judging the credibility of that witness. Is this person coming across as credible, or are they coming across as shady and I don't really trust what they're telling me? Especially once the other attorney starts to cross-examine that witness, do they start to poke a lot of holes in what they have to say? Children are witnesses too, and a judge is looking at that child and trying to determine credibility as far as that child too. And I will tell you, children are just like adults when it comes to credibility. I've seen some that are very credible and you can tell it's from their heart and they're telling you the truth. And then there are others that are not. So can extreme alienation, can the judge just take a child's word on it? Yes. I would not want to rest my whole case on what that child is going to say when we go to court that day. But a child that comes in and is very credible and tells the judge something from their heart, a judge is going to listen to that.
Yeah, it's crazy, Kevin, because just last week I heard a testimony from an 11-year-old that came in and said, look, I said a lot of stuff on the stand when I was a child, but it was what I was told to say. And I understand I did that, but I was a kid. And this has wrecked my whole life. I want to be with my father. And he didn't do the things, but that's what we were told. I'm older. I realize what's going on now. I'm in pain in my current situation and I want to get out of it.
Right.
But the case had been decided off of what this child said when they was, like 5, 6 years old.
And it's not that child's fault. It is a huge ask to try to get a child to go against what their parent is telling them is true and that you need to believe this and you need to say this. What young child is going to be able to go against that? It's not going to happen. And now that child's probably got guilt now, even though it's not his fault. But that's what happens.
Children don't want to be up there in the first place. So if they've got something that someone's told them to say, all the more easier for them, especially at that young age. I hate to say they believed in Santa Claus. Robert Garza used to talk about that all the time too. They believed in that from their parents saying it. They'll believe anything as a child because they've got someone that's supposed to love them and be caring for them, telling them this story.
Exactly. That's true.
Yeah. I'm sorry to hear about that, Matthew. We got one in here from Nikki Marie Nash. She said, is there a way to bypass a referee and have a judge see your case? We have only ever seen a referee, but our judge is not near as biased against fathers.
I'm going to have to plead some ignorance on that, Nikki. I don't know what state you're in. We don't have referees and judges. We have just judges in Arkansas, so I'm not really familiar with that process. I'm
not either. And that's the hard thing about it. Although it's very similar, every state's different. So, Julie Adams said, if you file a motion to expedite a hearing and it only gets moved 20 days, still leaving you I'm guessing she said still leaving you with a 10-week wait, should you file another to get it moved up further? The kids are being severely manipulated by the mother to the point they believe things she tells them that did not occur, even about events they were present for. Totally out of touch with reality. It's scary.
I can't give you a good answer on that, Julie. You need to talk to your attorney. Normally, if I've asked for a hearing to be moved up and kind of explained it to the judge why we need it and that it's very important, judge, that we get this moved, and they move it closer 20 days, my first thought is that was the best they could do for you. They clearly listened to what your motion said and they wanted to try to get it faster for you. And they were apparently only able to move it 20 days closer. I don't know that asking again is going to help. You don't want to tell a judge too much about how to schedule his or her calendar. So you have to be careful with that. Usually I would just tell my client that, we did, this is the best we could do.
Sure. Vivian Mendez said, how does it look in court when mom denies visitation over and over? Dad has just begun the process for custody visitation. No court order yet. Just emails between lawyers trying to establish a visitation schedule. But she denies 3 times already. Trial is set for June.
Okay, this is what I call you're kind of in the no man's land. Everybody knows it's your child, but there's not an order in place yet. There's not a visitation schedule in place yet. There's really no reason, from what I'm hearing here, to deny the visitation other than mom just doesn't want to provide it. So can you use that information? I do. I think I do want the judge to know about it. If we have to go to court over it, that, look, judge, everybody knew this was the father. He has not harmed this child. There's no reason for him to not have visitation, and mom, just out of spite, was not allowing it. I think the judge needs to know about that. Now, you know what the response on the other side is going to be. She didn't have to provide visitation. There wasn't an order in place. She just didn't have to do that. So how much that really moves the needle in your case just depends on the case. But yes, I would bring it up. And hopefully, I'm glad to see the attorneys are talking. Hopefully, they'll get some kind of schedule put in place.
Yep. Following up with the question earlier from David when he was asking, should a step parent that's not allowed to see their biological children be allowed to be around someone else's children? He had a follow-up question. He said, the step parent has a court order from the biological child, the siblings, and ex. Should this be brought up in court?
So he's got an order that he can see the biological child?
I'm thinking it must be he can't.
To me, it comes down to why. What happened? I mean, if he abused the child and the judge came in and said, you're not going to see this child again, that's an issue. But there may be some other reason there. I'm just not sure on that.
Yeah. Clyde, he's given us a blessing, Mr. Blessing, in here. He said, I had shared parenting before my attorney told me I needed to give it all to go for custody of my children. Well, I lost in the question. I have now. Can I go back to court and to reissue shared parenting again, or does she have to agree?
Parenting before my attorney told me I need to give it all to go for custody of my children loss. You're probably back to that change in circumstances language. You've got to show that something has changed, or what you put there at the end, that she agrees. If you can talk with her and get her to agree to some kind of shared parenting or joint custody, then you could do an order, and most judges are okay with that and will sign it if the parties have agreed to it.
Yeah.
And this goes back to what we were talking about earlier. How long? One of the questions I would ask Clyde is, how long has it been since you were in court? If that was 3 years ago, you may be able to go back now. But if it was 3 months ago, you're probably stuck with what you've got unless she will agree to change it.
Yeah, Clyde, I can't answer you on the legal side, but what I would tell you, brother, is talk to them and, say, look, you name a place that where you can come and sit down and talk about the best interest of the child. I'm not wanting to work against you. I want to work with you, and I want to be in my child's life. Give some type of grace. Anything that you can do outside of court is going to have much better results than going and spending all your money and doing that. So that would be my best solution for you, brother. Try to go eye to eye, kind of like Kevin was talking about.
There's research on that too, Eric. You were just talking about if you can agree to something out of court. The research across the country for years has been very consistent that parties that reach an agreement on their own, either through mediation or just through their own talking, and they come up with something that they want to do, are much more likely to keep that agreement and that order in place longer than if a judge just came in and said, here's what you're going to do. So if you can reach an agreement, it's usually much better.
And Kevin, you're going to have the ones that says, no matter what I do, it's never going to happen. Well, guess what? You don't know unless you try. If you don't ask, the answer is always going to be no.
I've tried to stop being surprised. There are some people that come in cases that get started, and I say, there's no way we're going to settle this case. And we do. And then others that I think this is going to be easy and we're going to settle it. And it becomes the most contentious case I've ever had. So you just never know. You never know what's going to happen.
Emotions are high in divorce. I mean, there's something there that made you want to divorce, or maybe you wasn't married that made you want to split up. If you can calm down those emotions, it's where you can keep the focus on the kid. I think that's where a lot of people fail, put some water on the fire.
Yeah, that's true.
Yeah. Mr. Scott Price said, why does it seem like best interest of the child is totally ignored? A pros and cons list can be so obvious: stable biological family relationships, financial stability, resident school, extended family, history of each parent, etc.
Well, those are all the things that judges are looking at. And I mean, that's the kind of things that they're trying to weigh back and forth when they decide what's in the best interest of the child. As far as I don't know that I would agree that it's totally ignored, at least not in my experience. I think the vast majority of judges I've dealt with have understood that's the standard they've got to be going by, and they've applied it.
And I think it's, fair. Scott, Kevin's in Arkansas, one of very few states that actually went for 50-50.
That's correct. Yeah. We just passed shared parenting, and it goes into effect in August of this year. So we're going to have a brave new world here really soon, and probably a lot of appeals. And I've been talking to a lot of attorneys about it. It's going to be interesting once that goes into effect.
Yep. Absolutely. Brenda Padot said, is it normal for attorneys to meet in chambers with judge to discuss case without clients?
Brenda, that is an excellent question. It depends on the judge. Some judges want to talk to the attorneys beforehand to kind of get an idea of what the case is going to be about. I will say it's not abnormal. If you just had a case and your attorney said, look, the judge wants to talk to us, that happens. And I think, and I try to look at this from the client's point of view, that's probably not very good optics. It probably doesn't look or feel right to a client, and usually clients will have some people there, either a friend or family member. And I know that when the attorney says, look, we're going to go back and talk to the judge, and they're gone for 20 or 30 minutes, it can't be a very good look. But normally the judge is just wanting to know, hey, how many witnesses are you going to have? What kind of timetable are we going to do today? Is there anything unusual I need to know about? I mean, that's the kind of things that the judge usually wants to know.
Yeah. Emily Ryan said, what good does signing an acknowledgement of paternity do before custody visitation court? My fiance's ex has asked him to leave her and child alone because he's not legally the child's.
Well, the acknowledgement of paternity many times is signed at the hospital, and it is a notarized document that says you're the father. And the good that it does is it speeds up the process of paternity. You still usually have to file that paternity action with court to legally be declared the father. And if you've got an acknowledgement of paternity, that can move that along. Sometimes people still want to do DNA testing if they think there's a possibility the child might not be theirs. Yeah, just the acknowledgement of paternity, and I think this is what you're asking, Emily. That's not enough to automatically legalize the man as the father. You've got to usually file something with the court.
Oh, and she followed up down there and added another sentence to it. She said, if neither party is denying the father, why do we have to go through a paternity hearing?
You wouldn't have to necessarily go through a hearing. When I'm representing a dad in that situation, I ask if mom is willing to to agree that he's the father, if he's okay with that. And if she is, we get her to sign an agreed order saying he's the father, and we get a visitation schedule set up. If you get it all agreed, you don't have to actually go to court. You will still file it with the court, but an attorney can send that over to the judge and get it signed, and you're done.
I will say, talking to my buddy Carnell Smith, who went and got paternity fraud legislation in 11 states, he always tells me, if you get it through the court, it's much cheaper. It's your one time to get it. So, I mean, you can waive it if you're 100% sure, but I like that.
Yeah. Well, people, and she's got a good question. She's probably thinking, why do we have to go through all this? I mean, everybody's on board with he's the father. Why do we have to do all this? And I think a lot of people get real concerned with costs and time, and oh my God, this is going to take months and everything else. Call up an attorney that handles these kinds of cases and say, I need 30 minutes. What will it cost me to come talk to you for 30 minutes? And ask these questions. And I think if more people did that, they would see it's much more affordable than they think. And I think they'd get answers that would set their mind at ease over some of these things.
Yep.
But a lot of people don't know that. They get intimidated by the legal process, talking to attorneys and all of that. Attorneys are people too, they won't bite. So just go talk to them.
iTumbler said, I filed a TPO on behalf of myself and child. It was granted. It's for stalking, harassment, battery. I have video evidence. Police report. Any thoughts on final hearing? What should I expect?
I'm guessing what that means when you say it's granted, it was probably the ex parte part. So what's being talked about is if you go out, file for an order of protection, usually the judge will sign and give you one immediately. It's called an ex parte, which means the other side hasn't had a chance to present their side of the case yet. But to err on the side of caution, briefly, judges will give you that order to give you protection until you can have a full hearing. So I think what's being asked is, what do I do at the final hearing? Well, at the final hearing, you bring all that evidence. You're also entitled to have an attorney help you with it if you want, but make sure you have all that evidence, any witnesses that can testify for you to say that it happened. If you had to go to the hospital, you were injured in any way, if you have photos of your injuries, medical records, try to bring all of that.
Yeah. Ann O'Keefe Rogers said, do you have any insight for parents who are financially tapped out and have to go pro se? I know you was working on something.
I was, and Eric and I talk about this a lot, and obviously the first opportunity or first thing you think about is not to just go to court pro se. If you have to, there's a lot of resources out there. Google Scholar is one thing that I've used a lot, that I use, but a lot of people that are pro se can use it, can give you some case law and things like that. I have considered starting a service for clients in that situation, or people in that situation that want some do's and don'ts for going to court. kind of a pro se clinic kind of thing to talk about a little bit of evidence rules and presenting exhibits and how to address the court and that kind of thing, just to give you a general overview. So you may want to try to talk to an attorney and see if you can pay them for a little bit of time and to help you with that, somebody that's in your area.
Yeah. Stephen Creasy said, if my ex tried to do child support on me for the first time and didn't do the DNA test, and they closed the case, and now she's doing it again, and she took the test, is that going to help me in court?
I mean, it just depends on the DNA test. That should have been done the first time around. I mean, I think the fact that she didn't do the test, I don't know how much that'll really factor in the case. I mean, obviously the DNA test is to determine if you're the father or not. So it's either going to determine that it is or it's not, or that you're not. So I don't know, other than that, how much that's going to make a difference.
Yeah. Timmy Wyndham said, what can you do if your attorney keeps allowing the other attorney to cancel court without your approval? How do other attorneys cancel court without filing a motion?
Sometimes the other attorney will pick up the phone and call either the judge's office or the other attorney and say, look, I need a continuance. I'm sorry, I've had this come up or that come up, and I need to move the court case. As an attorney, there are times when I will say, sure, that's fine, without consulting with the client. It depends on the case. If there have been 2 or 3 continuances before, and it's been months that we've been waiting, and we're about to have a full-blown hearing and we're ready to go, and the other attorney wants a continuance, I'm going to talk with my client about that and figure out what we need to do, because we may want to object to that. But if it's happening over and over, that is a bit of a problem, and you need to talk to your attorney about it.
Kevin, no, I'm trying to bring you some questions. Somebody asked something real quick I want to address. David Blake said, hey, Eric, what happened when you came to South Carolina? Hey, David, we was up there. We got someone on the other side of the aisle that wants to sponsor the bill. There was great conversations going on. All of your legislators will need help up there. They're willing to fight for it, but they're going to need you to help fight for it too. Sad thing is, a lot of times when people get this going, not much support shows up. So they're going to get it in there, and I can guarantee you next year you've got one of the strongest sponsors and one of the best representatives I know, Mr. Jonathan Hill and Stuart Jones up there that's wanting to fight for it. We had some great conversations, so there's more people signing on to it. Wait for some news to come up on that. Nicholas Dean, Kevin, has said, is it possible to show alienation and not get CPS involved?
Oh, absolutely. Now, when you say alienation, there are 1,000 different behaviors that can fall under that name, a lot of which would fall under substantial abuse, and that CPS probably would end up getting involved. But you can absolutely show alienation without getting CPS involved. You just have to present the evidence to the court and go from there. CPS 9 times out of 10 gets involved because someone makes a hotline call. And if there aren't any hotline calls made, or something doesn't happen at school or something like that where there's mandated reporters, then many times CPS won't get involved. So I would just proceed with showing alienation as best you can through documentation, evidence, etc. And if CPS doesn't get involved, to me, that's a good thing. I never like them to get involved in my cases.
Absolutely. All right, guys. Well, that's going to be it for tonight. Kevin, I appreciate you coming on and answering these questions for everybody, man. I've really enjoyed getting to know you ever since this went down with John Mast. Do we have any updates on that case right now?
Nothing as of yet. No, nothing as of yet. Just still waiting.
Yep, guys, and I can assure you, as soon as we get some information on that, we will make sure to update you. Kevin, if anybody wanted to get your services, how could they reach out to you, and where all do you serve?
We, well, the first thing would be to go to our website, which is kevinhickeylaw.com. It's all one word. You can also call our office at 479-434-2414. I'm also on Facebook, Twitter, Instagram, and LinkedIn. You can find us on there. Usually any high conflict custody cases, that's a lot of what we do is child custody. I take high conflict custody cases anywhere in the country, which means if you have a local attorney that you're working with and you wanted to bring us in, then I would be co-counsel with your local attorney and would get admitted into that state for that particular case and work alongside your local attorney.
Yeah. All right, man. Well, I sure do appreciate it, guys. 2 weeks from today, we will be back on Monday. We should be back next week with Melissa Isaac and Rhett Clark. Got a full week lined up. We'll give you the updates as we get it. Kevin, it's been real, man. Thank you again for coming on.
Always a pleasure, man. Take care.
All right, guys.